what happened here was reprehensible. I mean, the evidence was overwhelming that there was a recount that was rigged here. What's more troubling, there isn't anything more troubling, or more sad in this case, is again, from the state's perspective, that these defendants have never come clean, have never admitted what's been going on. Now, Ms. Dreamer and Ms. May referred to conversations that we had. Just for the record, once again, when I got in this case, one of the first things that I did, besides reading the memorandum from Leonard outlining this case, virtually met with these ladies. I will represent to this court that they never said anything about any precincts being swapped out, anything being compared for purposes of substituting precincts for those that balance with the poll books or with the official count. In fact, Ms. Dreamer was visibly upset that even someone would even make such an allegation. So we continued on. We presented this case to a grand jury because at that particular time, it became apparent that there was at least some inconsistencies, or at least some people that weren't becoming truthful or coming clean in this investigation. We spent two and a half days in grand jury. 15 witnesses in grand jury. They were subpoenaed, they didn't testify. The ink wasn't dry on the indictments on August 30th when the Board of Elections, under the supervision of Chairman Bob Bennett, issues a press release saying we are confident that no employee of the Board of Elections would knowingly or negligently engage in any unlawful conduct regarding the 2004 presidential recount. We as board members unanimously stand by our employees in the face of these allegations. The board then, after Ms. May was later indicted, the board then issues another statement saying the investigation must stop. Then just a couple weeks ago, Bob Bennett happened to be in the Sandusky area, speaking to the Republican Party there, and he calls these convictions a travesty of justice. He says that they did nothing wrong. He believes they'll be eventually overturned. Now, when you look at that, what I would say is vigorous and amazing support from a public body of people who were indicted by a grand jury and now convicted by a jury of violations of election law, felony violations. It's amazing. It's astounding. And then you look at what the state believes is not coming clean these people as to what happened and who was involved and more precisely who instructed them to partake in this. Let's talk about that. We have two different proffers that you talk to these people about.
Brian, may we approach?
Jack,
May we approach?
sure.
All right, the objection is overruled. Mr. Baxter, you may continue.
Once again, Ms. Dreamer in her proffer states that she was instructed by Ms. May to discard ballots that didn't, or precincts that didn't balance with the poll books. Meanwhile, Ms. May, as she stated here, and in her proffer, saying that she didn't know anything about any in fact, I'll read were discarded from the random sample because it did not balance with the poll books. I never instructed anyone to discard any precincts or to verify numbers for the poll books. This had never been practiced for the department. I do not believe that Kathy Dreamer or Rosie Greer discarded any precincts. And then Ms. Dreamer also says that she's not aware, either sentencing or whatever, she says that she's not aware that any precincts were discarded or counted when we compared the official count, which was the second triage, if you will, to exclude and substitute and swap out certain precincts. Yet all the evidence, including Jim Santoro, who testified to this court, says that they did that at the direction of the manager and the assistant manager, Kathy Dreamer and Rosie Greer. So, to suggest that these folks, these defendants, have been honest with the prosecution, or at least even consistent with what the overwhelming evidence is just not true. It just hasn't happened in this particular case. They violated a public trust. They were in a public position. They were there, like the Board of Elections, to protect the public, to maintain the integrity of the election process, which is vital to every component of our system, in our society. You know, Ms. Dreamer, in a number of her different places, in her sentencing memorandums, page 7, page 10, page 12, page 13, says she didn't know that this was wrong. She didn't know that this was illegal. She had no criminal intent, no knowledge of that this was illegal. Well, geez, we got her on December 13th, the DVD or video that was shown to the jury, where she was evasive, this man was dishonest, they were hiding the ball, and Cyrus Taylor, and Kathleen Wynn, and Ms. Lovegren, who were questioning about the process. Little did they know, we found out through the others in this case, that they were really in the process at that point in time of writing this recount. Then later, on December 16th, Ms. Maiden, at the official recount, when asked by Sarah Taylor, who took the stand and testified here, when asked, are the ballots as they came out of the machine? She said yes. She doesn't go into any of this recount, any of this 3-day process they went through. And in that video, in that DVD, at some point, Ms. Dreamer is depicted there. She's present. She's listening to this. Later on, Ms. Maiden appears at a couple board meetings. These are public meetings when the cat's out of the bag. And she's at those public meetings. And she says, first of all, we only looked at the total count. We were not looking at who won, who lost. Well, we know that's not true. We heard the evidence. That's how they arrived at whether or not they were just going to discard or swap out certain precincts. And then later, at a subsequent meeting, when Mr. Taylor, the lawyer, Candace Hoke's husband, George Taylor, appeared at the meeting and said, we have information that 3 or 4 precincts, at least 3 precincts, were counted, were pre-counted, were pre-sorted. She then backs up and says, yeah, well, 3 or 4, but that's it. No profit. She says the same thing, 3 or 4, but no more. That was it. Well, we know that's not true. We know that all 34 precincts were counted. So, I mean, I think the court in the state is in a predicament, Your Honor. I mean, this is a sad case of these ladies, these defendants, having an opportunity after opportunity after opportunity after opportunity to simply tell the truth. Not only for the system, but also for themselves. And they have refused to do so. I mean, it's abundantly clear. So the question comes down to, and one of the criteria that Mr. Sinenberg cites in his sentencing memorandum, which is, of course, in the law, is that they are in a public position. They're holding a position of public trust. And not only did they violate that, reprehensibly so, but then they covered it up. And they concealed it. And I believe, Your Honor, the state, I should say the state of Ohio, believes that they're still doing it, even to this day. Why? We can only speculate at this point in time. Also, Mr. Sonnenberg indicates that under 29.12B, he identifies 9 factors in his sentencing memorandum, of which he maintains that none apply. We disagree. 3 says the offender held a public office or position, trust in the community, and the offense related to that office or position. Clearly that applies here. Clearly that applies to misdemeanor as well as misdemeanor. Number 4, the offender's occupation, elected office, or profession obliged the offender to prevent the offense or bring others committed to justice. Certainly, manager, election coordinator, these defendants were obliged to maintain the integrity of the process in the election. They had the duty to maintain the laws incumbent upon them by the revised code as well as Secretary of State. That applies. And number 5, the offender's professional reputation, elected office, or profession was used to facilitate the offense or was likely to case of future conduct. It certainly was used to facilitate the offense. They couldn't have done it unless they held these positions of trust, these public positions of trust. Also, the fact, we're talking about no restitution. What about the $14,360 to leave right there? They get a phony recount. They're out the money. I mean, restitution should be made somewhere along in this case. I don't know if it's apparent here. I'll leave that up to the court, but I think that's a point that sometimes defense counsel misses or doesn't elaborate. So, for those reasons, Your Honor, again, at first glance, you look at these ladies, you look at these defendants, community sanction certainly seems to be something that's appropriate, but when I go through this process, what happened? And after the fact, it just seems tough to put them on community sanctions. It seems like if they're not honest now, how are they going to be honest during community sanctions? Something this court has to monitor. Is this how we want to start out, being on probation? So for all those reasons, Your Honor, I don't think community sanction is appropriate. Certainly, we don't the court's getting a sentence. I don't have any magic sentence against this is a very difficult situation not only for the court, because I know you have to make a difficult decision. I certainly don't envy you in that position, but it's also difficult for the state. I mean, it's not something that the state will ever wanted to pursue through to this point, but it comes a time when, in the face of what seems to be an obvious subterfuge or obvious concealment, there's no choice. So thank you.
All right, Mr. Sonnenberg.